Lord Steyn once said in a case, "Ideas divorced from reality have never held much attraction for judges steeped in the tradition that is their task to deliver principled but practical justice."
Well, that's very interesting, isn't it? As he is author of some judgments that could easily be criticised for lack of principle.
Well, but practical justice certainly is what we're contending for. Now, that particular case was Lister against Halsey Hall Limited, 2002, 1 appeal cases 215,
Yeah.
paragraph 16. Facts were striking. It was vicarious liability, warden of a boarding house abusing pupils aged 12 to 15, and the Court of Appeal had found that the claimants weren't entitled to sue the defendants, there being no vicarious liability. And so Lord Steyn went on to say in that passage, preoccupation with conceptualist reasoning may lead to the absurd conclusion that there can only be vicarious liability if a bank carries on the business of defrauding its credit customers. Now, we submit that in the present case, Mr. Justice Knowles was absolutely right in his decision as to reflective loss. His decision delivered on the facts of the present case, principled, we say, but practical justice, and his decision should be upheld. Now, on this appeal against the decision of the Court of Appeal, reversing part of Mr. Justice Knowles' judgment, I appear for the claimant, Marex Financial, with Miss Sophie Webber. The respondent, Mr. Sevilleja, is represented by Mr. David Lewis, Queen's Counsel, and Mr. Richard Greenberg. And there's an intervention by the all-party parliamentary group on fair business banking. My learned friend, Mr. Peter Knox, Queen's Counsel, represents them with Simon Reevell, Richard Samuel, Amit Karia, and Chloe Shuffrey. The problem, we say, in the present case is that the no reflective loss rule is being used to prevent a person with a good cause of action from relying on the cause of action to recover the whole of the loss intentionally inflicted by the defendant wrongdoer. And the result follows applying rules without regard to their implication in the particular case. The proposition is that the two companies of which the claimant was judgment creditor could in theory have sued the defendant once he had stolen their money from England, but in reality there was never going to be and never will be any pursuit of the defendant by those companies. That was the defendant's plan. Now, in the Court of Appeal, it's right to say that the court felt bound by the rule against reflective loss as a matter of precedent, and one can see that in particular reflected in the judgment of Lord Justice Lewison at paragraph 69 to 71, page 171 on the electronic bundle. But the Court of Appeal were concerned, we submit, about the implication of their decision because they took the unusual step of giving us permission to appeal. The core propositions which I will be submitting to this court are as follows. The first one is that the Johnson and Gore Wood case was, in fact, as a matter of decision, less striking than it has been regarded subsequently. In particular, it was only a shareholder's case. That was to say, the claimant affected by the rule was only a shareholder. It concerned diminution in the value of shareholding. That was captured as reflective loss, and also loss of future distributions. That was captured as reflective loss. But what was not captured as reflective loss was present debts, and nor indeed, as captured reflective loss, was realized loss in relation to devalued shares. The second proposition is that accepting for the sake of argument that debts, whether secured or not, in principle qualify for exclusion under the reflective loss rule, a condition for exclusion is that the claimant being excluded from bringing his case to court or bringing his heads of loss to court must be a member of the relevant company. My third proposition is that in any event, reasons of policy behind the rule don't apply to pure creditors, whether secured or unsecured. And it's a fact that the most prominent policy reason relied upon for the rule is said to be double recovery, preventing double recovery. In fact, Mr. Justice Hart, the late Mr. Justice Hart, described the rule as the rule against double recovery. Then again, my fourth proposition is that the policy reasons, in particular, don't apply in our case. It's unreal to regard our loss as caused by the failure of the liquidator to sue. That's a point my own friend suggests. The absence of suit from the company was part of the defendant's plan. And one can see also that although the companies have creditors besides us, all those creditors are connected, they're all close, and none of them have bothered to take any steps to motivate the liquidator to do anything. They are creatures of the defendant, and they're to make sure that the case is obstructed, that we don't actually get any payment by any means. The fifth proposition is the Giles and Ryan exception, which is discussed below. It can be viewed as an exception to the rule against reflective loss, but we say that in fact it's an aspect of the principle that where the policy reasons don't apply, the rule should not apply. It should be available, in particular, where a claimant is only a creditor of the relevant company, and where, as a matter of practical reality, the claimant is shut out from pursuit of the intentionally inflicted wrong caused by the defendant. The exception, Giles and Ryan, shouldn't depend, as the Court of Appeal thought, on it being demonstrated by the claimant that there's legal impossibility in the subject company pursuing the defendant. Much less should it be that there's a factual impossibility, where the reality is that there's not going to be a pursuit of the defendant. The rule against reflective loss should not apply. The facts of the present case are stark. In July 2013, the two Garcia companies, that's Creative Finance Limited and Marex Limited, became judgment debtors of the claimant. In the face of their judgment, even before the judgment had been delivered, but at a time when it was in draft, the defendant was removing the entirety of the company's assets from England. And those assets were then dissipated and became untraceable. The circulation of the draft judgment was the 19th of July, and the hand-down was the 25th of July, 2013. The amount removed was over $9.5 million. The amount of our claims, our judgment debts, was at that time something like $5.5 million. The removal was despite the company's lawyers having asserted in correspondence in May 2013, quote, "Our clients confirm they intend to continue to honour their financial obligations as they always have." And that reference is to be found at pages 292 and then again at 323 of the electronic bundle. The irresistible inference is that the removal of the English assets, engineered by the defendant, is to prevent the claimants collecting from the companies on the judgment debts. What's more, the defendant doesn't dispute our proposition that had the money remained in England, had a freezing injunction been obtained, we could have had that money in short order from the companies on a third-party debt order. But that was prevented. So the money was lost to us when it was removed from England, and the availability of a third-party debt order vanished. Now, just to deal with a point which has been raised by my learned friend, at paragraph 8 of the case, the defendant's case, page 2721 of the electronic bundle, it said that we have made a concession that if the companies sued, we could have our money back, and that there's actually no distinction between shareholders and creditors. This is from the fact that we accepted, and have accepted for the purpose of this appeal, that our loss is to be regarded as reflective loss. But what we understand by that is that when the companies were wronged, by the same breath, our loss was suffered. The money was taken, it was no longer available to us, it was no longer available to the company. Had the money been returned immediately after being taken, we would not have suffered the loss that we have. The loss to the companies, if you will, using an expression of Lord Millerton in Johnson and Gorwood, franked our loss. But that's as far as our concession goes. On the facts, and I will go further. On the 12th of December 2013, the defendant had the companies put into voluntary liquidation in the BVI. That liquidation followed a process that we had gone through in the United States of having our judgments domesticated there, which gave us the possibility of seizing a debt that was due to the companies in the United States. There's a finding made by Judge Gerber in the United States Bankruptcy Court for the Southern District of New York that the voluntary liquidations themselves were orchestrated by the defendant and were part of the process of defrauding us, the claimant. And this finding followed live evidence given by the liquidator to the court on the 10th of April 2014 and the 24th of June 2014. The reference to the live evidence can be found at page 219 of the electronic bundle. But what I wanted to do was to show you a few passages from the judgment of His Honour Judge Gerber, which are really very telling. The first one is at page 338 of the electronic bundle. It's core bundle divider 6. The first finding is a comment by the judge. It's rare in Chapter 15 cases, Chapter 15 being to try and get the judgment, the liquidation recognised in the United States.
Would you be kind enough to favour us with a page number from the electronic bundle?
It's 338,
Thank you.
my lady. I apologise. The sentence that I rely on, it's rare in Chapter 15 cases for foreign representatives to do such minimal activity on behalf of the estates for whom they have been appointed, and even rarer for that to happen by design. And then on the next page, page 339 towards the bottom, the learned judge commented, by reason of the minimal activities by the liquidator in the BVI, as orchestrated by the debtor's principals, the debtor's centre of main interest never changed. The liquidator never developed a comia in the jurisdiction in which he was appointed, and Chapter 15's statutory requirement for recognition as a foreign main proceeding was not satisfied. And then he goes on to deal with recognition question in the United States. But on the next page, on that same page 340, likewise, the court does not need to decide what it would have done with the egregious bad faith it finds here if recognition, especially as a foreign main proceeding, had to be granted. But the court observes that in Chapter 15, as in Chapter 11, US courts need not tolerate debtor bad faith. Then at the next page, page 341, under the heading Factual Summary, as described in more detail below, this Chapter 15 case is brought as one of several steps in a scheme by the debtor's principal, that's the defendant, referred to by the liquidator as Carlos, to exploit a BVI liquidation proceeding as a device to thwart enforcement of a $5 million judgment against the debtors that Marex won in the courts of England, and the most blatant effort to hinder, delay, and defraud a creditor this court has ever seen. And then the next page, page 342, and I would commend to the court the whole of the passage that starts with Sevilleja caused the debtors to file their involuntary insolvency proceedings in the BVI, through to the end of the first complete paragraph on the next page. From the beginning to end, Sevilleja's tactics were a pragmatic example of bad faith, and the liquidators' actions and inaction facilitated them. So that's the view the United States court formed of the present case. And one has to say that it would be remarkable if the English courts weren't able to give the claimant justice, which this process of stealing the company's assets and then bringing a voluntary liquidation in the BVI has brought about. The rule against reflective loss has been recently equated to some ghastly legal Japanese knotweed. And that's in an article by Professor Andrew Tettenborn, which is to be found at page 1665, which is in the Principal Authorities Bundle 2, divided 24. And the reference to the Japanese legal knotweed is at page 1167. His article is captioned "Creditors and Reflective Loss, a bar too far." I would commend that article to this court. Essentially, I could adopt what the professor has there written as my submissions. He makes the point, absolutely rightly, that the reflective loss rule, barring a claimant from bringing proceedings to recover the lost debts, is simply not justice, and it involves taking the rule against reflective loss way too far. And it's not only an academic in that recent article who's been concerned about the rule against reflective loss. English judges, too, have been concerned about the implications of the rule and how it operates we would submit, to deliver injustice, and certainly not principled but practical justice. So, Giles and Rind, that's Lord Justices Waller, Chadwick and Keane, they were convinced that a way needed to be found to allow the claimant to pursue the defendant in that case. And that actually was acknowledged by Lord Millett in Waddington against Chan Chun Hu Thomas at paragraph 85. The reference to Lord Millett's judgment given in the Hong Kong Court of Final Appeal is at page 1052 in the electronic bundle. And in that passage, Lord Millett was concerned to explain why Giles and Rind was wrong, why it shouldn't be part of the law of Hong Kong, why it was not properly part of the law of England, England and Wales. But he went on to say, it's impossible not to share the determination of the Court of Appeal not to allow a defendant who has been guilty of such conduct to escape liability. Well, one has to say, if a rule that achieves the escaping of liability by a defendant who's behaved as the defendant had done in Giles and Rind, if it allows the defendant to escape, there's something wrong with the rule, I submit. Another case, Shaker against al-Badrawi, 2003, Chancery, page 350. That's to be found at page 912 in the electronic bundle, which is Principal Authorities 1, divided 12. Paragraph 86 at page 940 in the electronic bundle is instructive. Paragraph 86. It's in this paragraph, the Court of Appeal the Court of Appeal, having considered whether or not the claimant should be precluded from pursuing his proceedings, and having decided that he was not precluded at that stage, went on to say, we confess that we are the happier to reach this conclusion in view of the probability that A&A Inc., that's the subject company, would now bring an action against the defendant when it has not done so for over 8 years, since the payment of the $6 million to Cubic. And then they go on to express the observation about the Johnson-Gorwood prudential principle, the rule against reflective loss. In that case, the way that the Court of Appeal found that the claimant was still allowed to go on with the case all turned on the fact that it was debatable whether under the law of Pennsylvania, the subject company had actually been wronged. Money had been taken from the subject company, but perhaps it was a distribution that was lawful. Hence, the subject company would not have a cause of action against the defendant, and therefore the rule against reflective loss would not apply. But that was a matter which required investigation at a trial, and the Court of Appeal were clearly happy that a trial could go on. In Scotland, the rule has been considered by Lord Glennie in a case called MacLeod against Rooney. That's in the Principal Authorities Bundle 1 at Divider 10, page 859 in the electronic bundle, the relevant passage being at page 877. In the case, it was a case actually quite similar to ours in a way. There was an allegation of conspiracy against the defendant using the subject company as a target. The learned judge felt that found on the facts that that particular wrong pleaded by the claimant had not been properly made out on the pleadings. But he contemplated that nevertheless the case might continue, or a new case might be brought on amended pleading. And he also therefore dealt with reflective loss as a bar to the claimant's proceedings. And at paragraph 26, he makes the remark, whether or not it's right to regard Giles and Ryan as an exception to this rule, the importance of that case is that it shows that the court must take account of the reality of the situation. In a case where the company is disabled from pursuing the claim against the wrongdoer, the risk of double recovery is no longer a factor. If that disability was caused by the action of the wrongdoer, then the problem of causation is readily overcome. It seems to me that the court is required to look at the realities of the situation. And we would respectfully suggest that that should be not only the law in Scotland, but it should be the law in England and Wales too. Paragraph 28 on the following page, Lord Glennie made his observations about the application of the rule in the particular case. In the Channel Islands, the rule against reflective loss has been considered, and it's fair to say the court there, both in Jersey and in Guernsey, has found ways of sidestepping it where it sees that the justice so requires. In this context, I'd like to refer you to the judgment of Lieutenant Bailiff Marshall in a case called Jeffcote and Spread. This is to be found in Supplemental Authorities Bundle 4 at Divider 9. This is one of the bundles that came late. And the judgment starts, the case starts at page 2717 in the electronic bundle. It's 2717. So I'm going very fast now, I should slow down. 2717. Sorry. Forgive me, I'm quite wrong. Yes, it's 2717 is the beginning of the report. Yeah. 2788 to 89 is what I need in the electronic bundle. At paragraphs 373, where it's tab 9 in, there are lots of bundles. It's one of the thinner bundles, unfortunately. Supplemental 4 should be.
Yes, it's a different Jeff case from the one I was confused.
What happened, I have to say, is that some of the cases were incorrectly copied first time round, and this is one of them. That's why it appears in two places. Paragraph 373, Lieutenant Bailiff Marshall considered the law in Guernsey and made the point that Guernsey doesn't simply parrot English law, English and Welsh law. Then at paragraph 375, she referred to the fact that the rule is exclusionary and it prevents a plaintiff who has otherwise a recognized good claim against a defendant from making any direct recovery from that defendant. It's accepted even in English authorities, it should therefore be applied cautiously, and only in cases where it ought, according to its rationale, clearly be invoked. And then she asked herself, how do the principles behind the rule engage? And at paragraph 379, she commented, in those circumstances, the circumstances of the particular case, no double recovery, I find the policy reasons for applying the rule of no recovery for reflected loss in this case are really theoretical only and simply of no rate in practice. I do not see that merely pursuing conceptual consistencies for their own sake should be a principle which trumps practicality. The law of Guernsey is practical. In those circumstances, I conclude no reflective loss rule does not apply or will not be applied on the facts of a case such as this. And then paragraphs 380 is also relevant, but I won't read that out, and 381 too, where she refers to the Jersey case of Freeman and Ansbacher. That Jersey case for the court is to be found at electronic bundle 2145, which is Supplemental Authorities 3, divider 44, and the relevant passages are really at 2177 in the electronic bundle. That's Sir Michael Burt when he was deputy bailiff in Jersey. The Jeffcoat case was the occasion for an article written by Mr. Alan Steinfeld, Queen's Counsel, who the court may recall was leading counsel in the Johnson and Walker Wood case.
In that article, he confesses himself of being somewhat to blame for the situation in which we now found ourselves.
My lady's read the article, but he speaks of it. It's my learned friend's authority. He speaks of it, document, but he speaks of the rule as having been one that potentially can wreck injustice, and he says the law took a seriously wrong turn in Prudential. Well, I'll explain. I actually don't accept that it took a wrong turn in Prudential, because Prudential, the earlier case, was unremarkable and perfectly understandable. It's the Johnson and Gore Wood case where the wrong turn really happens. In Singapore, we have two authorities in
Sorry, can you give us a reference for the Steinfeld?
Sorry, Mr. Steinfeld's article is at the Intervenors Bundle 2,
Yeah.
tab 24, page electronic 569. That's anyway where
Thank you.
I just was quoting from. There are two cases in the Court of Appeal in Singapore which are relevant. One's Townsing against Genton Overseas Investment, and the other was Beckett against Deutsche Bank. The Townsing case is Supplemental Authorities 3, tab 52, electronic page 2307, And the relevant passage is at 2338. And then the Beckett case, the electronic version is 2232 at supplemental 3 divided 46. And the relevant passage is 2091. In particular, paragraphs 85 and 56. The point about those two cases is that one can see that in Singapore, where the court finds that there's not actually any real danger of double recovery, the
paragraphs in Beckett were?
It's actually 85 is the principal paragraph, but there's also a reference to paragraph 56 in Beckett.
Page number is not 2099. It must be.
It should be 2091. If I've
91. Sorry, thank you.
Maybe I've misread them.
No, I misheard you. I'm so sorry.
In case
You're quite right.
Yeah, it is.
346. Yes, it was 2091 is where paragraph 85 is to be found.
Thank you.
It's tab 42, and the case report begins at 2047.
Thank you.
So it was my mistake in the first place.
You gave us the right page number, but you gave us the wrong initial number for the...
That's right,
Yes.
my lady. My notes is incorrect. New Zealand, it's accepted that Christensen and Scott represents the present law, which is the case that the House of Lords thought not so well of in Johnson and Gorwood. In the United States, there's a slight difference between my learned friend and me. We say that the position is that in a case where practical justice requires it, a claim is allowed to be made by a claimant for reflective damage, reflective loss. My learned friend relies on the same document we rely upon, drawing attention to a Delaware case and saying that but the law in Delaware is different. So perhaps I should just show you the references to this. The electronic version is in bundle 3, tab 57, 2450. Now, this is an extract from the Principles of Corporate Governance. I think it was referred to by Lady Justice Arden in one of the earlier cases on Johnson and Gorwood. It contains the recommendations and exposition of the law from the American Law Institute. At page 2451, one can see that this chapter is concerned with derivative actions. Then at page 2463 comes the material paragraph 701, distinguishing between direct and derivative actions. And the principles are at letters C and D that are relevant for present purposes at 2464. The passage that my learned friend relies upon for his Delaware proposition is at 2478. Where he refers to a case of Bagdon and Bridgeton fire from 1990 in Delaware. But one can see, just turning back to the previous page, 2477, paragraph number 4, a discussion about a case in Massachusetts. The acknowledging there that in the case of a closely held corporation, which would be this present one, in our case, an exception to the general rule that only a derivative action may be used to seek redress of corporate injuries will be found. So supporting the proposition which we say is to be found in America. Massachusetts is certainly one of the well-regarded states in the United States, one talking about jurisprudence. It's not as though Delaware is the only state, and therefore one looks to the Delaware case.
I think you can guarantee that we're not going to make comparative judgments in the quality of the jurisprudence of the various states.
Absolutely, Maddy.
I
I wouldn't dream of inviting you to do that. But what I'm trying to say is that Massachusetts is certainly a well-regarded state when it comes to jurisprudence and the quality of its decisions. Now, one can see, my learned friend relies on certain of the Hong Kong cases, and I'll come back to those. But there's one that's, and he relies on these for the proposition that in Hong Kong, a pure creditor can be barred by the reflective loss rule from recovering damage caused to him through the impact of an injury on his debt or his claim. The one case in his list is a case called Veron International against RCG Holdings. And that was a case in 2015. It's referred to in my learned friend's case at paragraph 33.1, which is, it's on page 2737 of the electronic version. The actual case can be found in Supplemental Authorities 3, tab 53, page 2341.
234?
2341. It's quite a simple case, actually, and quite neat. It's a shareholder in a company. The company had a subsidiary. The subsidiary entered into a transaction which was loss-making, and the subsidiary had claims against the directors, quite likely, for that transaction. The holding company had governed the subsidiary, and there were likely claims that the holding company had against its directors for their failures in regard to the subsidiary. The claimant shareholder wanted to bring a derivative action, in fact a double derivative action, so that both the holding company would sue and the subsidiary would sue their respective directors. The Court of First Instance allowed the subsidiary's derivative action to proceed, but it refused to allow the holding company's derivative action to proceed on the ground that there was a reflective loss bar preventing the suit against the directors of the holding company in respect of what they had done. The curious feature of the case is that the directors of the holding company were not identical with the directors of the subsidiary. So the subsidiary had no cause of action, therefore, against those directors of the holding company. But the way that the rule is applied was to bar the holding company from suing its delinquent directors. And one would imagine that the upshot also is that the defendant directors of the subsidiary were going to be having trouble seeking contribution against their colleagues, the directors of the holding company. And that, we suggest, is where the rule is now being completely misapplied to prevent a claim that properly could be made by the holding company against its directors for loss that it had suffered through the impact on its subsidiary, where the subsidiary had no loss, no cause of action against those directors. In other words, the rule has become distorted so that essentially no longer can one sue somebody who's caused a wrong where the subject company itself has no cause of action. There in the authorities bundles, there are two cases from England on the question whether an injunction should be allowed as a way of enabling a person with a direct cause of action to pursue a defendant where the defendant is also injuring or threatening to injure a subject company. In other words, whether the reflective loss rule bars the personal cause of action where the claimant is seeking an injunction. Those two cases are referred to in paragraph 91 of our our case, at page 2606. One is to be found, Peak Hotels, at page 2649 in the electronic bundle, the other at page 1712. I won't show the court those particular cases in any detail because it's, if you will, a way in which the court has been moving around the reflective loss rule. But what I would like to show you is a more recent case in the Cayman Islands Court of Appeal, which is at Supplemental Authorities 3, tab 55, page 23, tab 55, I hope, page 2370. Now, in this case, one has quite an impressive Court of Appeal. It's Sir John Goldring, Sir Bernard Ricks, and Sir Alan Moses. And they were concerned with a typical holding company subsidiary structure in which it was possible that the activities of the defendants were going to impact on the position of the claimant shareholders. And injunctions were claimed to restrain threatened misconduct. One can see at paragraph 69 in the judgment of Sir Bernard Ricks, page 2399, a reference to Mr. Justice Neuberger describing the reflective loss doctrine as...
Sorry, I think I've gone wrong with the reference. What was the...
2399 electronic.
99, I'm sorry.
Is it paragraph 69 that you're...
69, my lady, yes. Where, referring to a case, Humberclyde, one of the early cases on reflective loss, the learned Judge of Appeal drew attention to Mr. Justice Neuberger's comment, this is a perplexing and developing area. And then he continued, dealing with submissions in paragraph 70, the proposition that the court has no discretion whether the reflective rule is engaged, a proposition that's taken from Lord Millett in Johnson and Gore-Wood, and also, I think, referred to by Lady Justice Arden, as she then was, in Day and Cook, before Giles and Rind. But at the end of that passage, Sir Bernard Ricks referred to Lady Justice Arden's passage in Day and Cook, saying, sorry, this is now Johnson and Gore-Wood, number 2, that the doctrine has a will-o'-the-wisp character, which needed clarification. Now, my lady, the President, my Lady Hale, will probably know the Johnson and Gore-Wood number 2 case better than anybody in this court, having been a member of the panel that decided that case, in which Lady Justice Arden made her remark about the will-o'-the-wisp character. That case I shall come back to, because it is concerned with, amongst other things, trying to decide what the House of Lords had decided on the pension claim in Johnson and Gore-Wood number 1. So in the Cayman Island case, the Court of Appeal found it, as one sees at paragraph 71, they found it appropriate and permissible to grant injunctions in a case where a damages claim would find itself confronted with the bar that the rule erects. My learned friend, in his argument, when considering, as it were, the merits of the rule, has referred to at paragraph 11.1 and footnote 12 on page 2724 of the electronic bundle. He's referred to an article by two members of his chambers captioned, "Reconsidering Reflective Loss, Are Creditors Barred?" And my own friend relies on this as indicating that the reflective loss rule, as applied in Marex, gets approval and should be upheld.
Sorry, where are you?
My lord, sorry?
Which page are you on?
It's my learned friend relies on it at 2724 in his case.
And the paragraph number for that?
It's paragraph number 11.1, footnote 12. Have I got that right, Sophie?
Now, where do we find the article?
And the article itself is 2546, and that's what I wanted to go to. It's in Supplemental Bundle 3, tab 67. It's written to deal with Marex and creditors' claims, I think, but certainly to deal with creditors' claims. And essentially there's a recap of the rule against reflective loss and how it's been applied in the past, and observations about creditors. And then one comes to the material passage, it's at 2546. This is the passage I wanted to rely on. The future. As observed by Mr. Justice Flo, although there are dicta in support of the proposition, there's as yet no binding English authority which concludes that the rule against reflective loss bars claims by non-shareholder unsecured creditors. And then he goes on to, the author's gone to say, the questions at large. And then they go on to say, the next paragraph down, our view is that on balance, the rule against reflective loss ought to apply to unsecured creditors. The rule is one that has its origins in principle. The principle is in essence to do justice as between potential claimants and defendants. A potential claimant should not be denied the ability to be compensated for a loss suffered, but a potential defendant should not be at risk of paying out twice in respect of the same loss. A reflective claim by an unsecured creditor almost inevitably offends against the basic rationale underpinning the rule. It's difficult to conceive of a reflective claim that would not prejudice one or more of one, the defendant who would be at risk of double liability to the creditor and the company, two, the company which would be unable to recover the underlying debt due to it, and three, the company's other creditors whose position would be worsened if one creditor was able to sue in order to, in effect, to prioritise one unsecured debt over any other. It remains to be seen whether that approach will gain full currency. I've left out of the passage. In the interim, to avoid becoming ensnared by the uncertain status of the rule, creditors seeking to make apparently reflective claims should consider whether they are able to formulate claims so as to present them as claims for diminution in the value of some personal asset, for example, as shows in action such as security rights. It's recognised this applies primarily to secured creditors, and that unsecured creditors are thus left with no direct cause of action. And then over the next page, the rule remains a trap that claimants must be alive to and for defendants to make use of, particularly in modern commercial litigation where a number of companies in a group might be involved, and due attention is not necessarily paid to the role that each party has in both the initial transaction in question and the litigation that has flowed from it. So to describe the rule as a trap and then say, actually, it's principled and should be upheld is in my submission, surprising. If it's a trap, it's probably a trap because it's counterintuitive. But actually, the reasons that have been articulated by the authors of this article, and reasons which are relied on by my learned friend, are actually, on further consideration, mistaken. The first one, and I'll come back to this, but in summary, the first one, is there's no double recovery. Supposing Mr. Sevilleja paid us our debts, he would step into our shoes. He would be able to prove in the liquidations which he had brought about in our place. And so he would have the benefit of that claim in the liquidations.
Is that because of some principle of subrogation?
Exactly, Moule and Garrett, straightforward, payment under compulsion of law. It's as simple as that.
Now, does that work if what he's actually paying is damages for the economic tort?
Well, in my submission, the answer is yes, my lord, because in taking the facts of the present case, our debt was in truth destroyed when our ability to recover it in England in the face of on the back of the judgments against the assets here was lost to us. So what we claim for is the full amount of our debt. And he'll pay that netting off the amount that we have actually managed to recover in America. But when he's paid us the full amount of our debt, that will actually have discharged our debt. We won't be able then to go to the companies and say, oh, by the way, we can now claim for the debt that has been satisfied by Mr. Sevilleja paying us. The other point, of course...
I just wondered if there was any... I mean, that seems intuitively right. I just wondered if there was any authority to support that proposition.
All I can say to my lord is I rely on Moule and Garrett that what will happen is that under the court's judgment against Mr. Sevilleja, he will pay us the amount of our debt. That is, if you like, the measure of damages. He'll also pay consequential loss, but he will pay us the amount of our debt. So he will have satisfied us. The other point, of course, here is that, coming to the second proposition, there's an inability of the company to recover the debt from Mr. Sevilleja, in other words, to recover the money stolen. That doesn't follow at all. The company's cause of action is unimpaired. The liquidator could still pursue Mr. Sevilleja for the amount of that he'd helped himself to. The only point, which is the third proposition, other creditors being prejudiced, the only point is actually the position of other creditors. On the facts of this case, that doesn't arise. The other creditors are not interested. See the fact that they've just done absolutely nothing, although their debts are greater than ours. They're there just to be obstructive. But as a matter of legal theory, they're not prejudiced either, because what would happen is that the companies would sue Mr. Sevilleja when he had paid the companies under the rule in Cherry and Bultby, the rule against participation in a fund. When he had paid the companies the amount of their money, then he would have the right to prove. But until he had paid the companies their debt, he wouldn't be entitled to set off the debt against the company's claim. And that's Cherry and Bultby. It's referred to, in particular...
Sorry, I didn't hear the name of the...
Cherry against Bultby. Perhaps I shall show the court... was going to come back to it, but I'll show the court now the proposition. It's Supplemental Authorities 1, tab 17, page 1532.
Let us see if I've got this right in my mind. If we keep the arithmetic simple and ignore interest, the company had assets of 9 million, you were owed 5 million. The 9 million gets taken away from the company and vanishes. You sue the defendant for the 5 million as damages caused by the economic tort of intentionally causing you the loss. You recover the 5 million from him as damages. You say the effect of that is that extinguishes the company's judgment debt to you. He is subrogated to the debt.
Yep.
But because of a rule, and the company can then still sue him for the 9 million that it had taken away from it. And you say that so far as he's subrogated to the debt, he can't set that off because of Cherry and Bultby, but he'll rank in the liquidation.
Yeah, exactly. Once he's paid the money, what he's taken, he'll be a proving creditor. And my learned friend has very helpfully put into the authorities bundle, tab 17, Supplemental Authorities 1, the Kaupthing case. It's page 1532. My learned friend relies on it for a proposition that the law objects to double recovery. There's some principle, and he relies on Kaupthing and then 3 statutes. The Kaupthing case was principally concerned with double proof. That's to say, whether a principal creditor and a guarantor could both prove in the liquidation, the one for the amount of the debt, the other for the contingent liability to pay the debt. And the rule against double proof stops that. That's not controversial. In the particular case, though, it was... Sorry, I think I've got the wrong one. It is right. I can deal with this. The court dealt with Cherry and Maltby and the rule in double proof, paragraph 8 on page 1541. And the passage I then particularly wanted, paragraphs 11 and 12, also deals with double proof and double dipping, which is not actually our problem in the present case at all. But paragraph 18 deals with the question that we are concerned with, which is Cherry and Maltby.
And the page for that?
Page 1544, paragraph 18. What is noted by Lord Walker is that the rule, that's the Cherry and Maltby rule, which has been started dealing with on the previous page, was applied in the compulsory liquidation of a company in Rhodesia Goldfields. Partridge, as director of the company, who had held some of its debenture stock, was facing a serious misfeasance claim which had not yet been resolved. Set-off was therefore not available. But Mr. Justice Svinfanidi said at page 247 that it be a strange travesty of equity to hold that in distributing the fund, Partridge was entitled to be paid at once all that was due to him out of the company's money, and subsequently to find after it had been established he owed the money to the fund, the money could not be recovered from him. Payment of what was due to Partridge and the assignees was therefore deferred until the claim against him was resolved. And that, as I understand it, is still good law. Rhodesia Goldfields represents the position. But for present purposes, on the facts of our case, this point doesn't matter because the other creditors are not interested. They've not done nothing. They've not exerted themselves. It's a pure formality. I've already mentioned paragraph 162 of the judgment of Lady Justice Arden in Gorewood number 2. That's at page 853. In that passage, the Lady Justice, as she then was grappling with the question quite what was decided in Johnson and Gorewood. But one point she did make was that as a result, really, of Giles and Rind, the need for creditor and shareholder protection, she said, is not always an absolute consideration and can be displaced. And we adopt that. We say that's absolutely right. And we support her comment. Now, Johnson and Gorewood, if I can take this as quickly as I can, it is relevant to understand what had happened before Johnson and Gorewood in order to then understand the case. And that one gets, indeed, in the present case, from Lord Justice Flo's judgment at paragraph 13, page 155 in the electronic bundle. What I submit about this is that the rule against Foss and Harbottle starts as a procedural rule, and the Johnson and Gorewood rule is likewise a procedural rule. That's why we submit correctly the law of England and Wales applies when one's considering how the rule should work in a particular case brought before the courts here. That was a point made in our case at paragraph 12. My learned friend relies on a case called Gray, which is relied upon as showing that the Johnson and Gore Wood rule avoids multiplicity of plaintiffs. The Gray case is just, in fact, an old original Foss and Harbottle case in which it's explained that one of the reasons for having the proper plaintiff rule, that if a cause of action is invested in a company A, the shareholders in the company can't sue on the company's own cause of action. The reason for that rule is because you'd otherwise have many, many, many shareholders capable of suing. So Gray is to be found at the relevant passages at page 1457 in the Gray case.
So when you say the rule in Foss and Harbottle was a procedural rule, I mean, it's really a consequence drawn from the separate personality of the company.
Absolutely, but part of that is that it, as a matter of procedure, going back before the modern statutes, as a matter of procedure, the court did allow shareholders to bring derivative actions in appropriate cases.
Yeah.
So it is really, in a sense, the court recognizing particular causes of action and then making a procedural decision as to how they're to be managed. It's the company which sues on that cause of action, not the shareholders. But in an exceptional case, an appropriate case, the shareholders can. And that is really what the Johnson and Gore Wood rule is all about. It's a procedural rule, we say. It's a bit like Henderson and Henderson, avoiding abuse of process. It's making sure that the proceedings, court's proceedings, are managed in an organised and coherent way.
I mean, it is a little bit more than procedural. I mean, it has substantive effects. I mean, if the company, through proper processes, decides to settle the action or indeed not to sue on the claim, and it's not in a case in the exceptional category, that will be an end.
But procedure does have effects. Henderson and Henderson is a classic example.
But the right of action is vested in the company. That's why the company is the person that brings the action.
In Foss and Harbottle, absolutely.
And I mean, unless there are reasons why the company, if a company is being controlled, for example, by directors who are not acting in accordance with fiduciary duties, then you allow derivative action as a means whereby the company can vindicate its rights through the agency of a shareholder.
Absolutely, yes, I accept that. But what I'm trying to, I'm submitting is that as regards the Johnson and Gore Wood rule, it's not a law about damages. It's not a law about cause of actions, which has come out of the common law. It's actually a process of managing the court's proceedings before the court. That's all it is. And that's why I submit the court should be able to say, as in the case of the ruling against Foss and Harbottle, that in appropriate cases, a claimant should be able to vindicate his or her own cause of action for damage which has actually been suffered by that person. The rule at the moment is preventing that. It's driving litigants away from the seat of justice. That's what I submit, is the practical effect at the moment of its application, in a case like the present one. Johnson, a prudential case, I think I should show the court page 897 in the electronic bundle, which is Principal Authorities 1, tab 11. This is, tab 11 is the prudential case itself. Page 897 is necessary to understand the lockbox example. The court, the lockbox is the case where the company's money is taken out of its lockbox. It has a cause of action for its own money. The shareholder who provides the key to the lockbox as a result of a deception placed on the shareholder has no cause of action. The reason is that the shareholder personally suffers no loss. The key has no value. The key can be regarded as a combination. It's not a golden key. that intrinsically has any worth. And the issue for the court was whether or not the deception practiced on the claimant had actually caused any loss at all. And one can see that at page 897, letters E to G in the paragraph dealing with the personal claim as at first instance, with the last part of that passage, therefore the plaintiff suffered some damage in consequence of the conspiracy, and that was sufficient to complete the cause of action. The quantum damage has been left to inquiry. That's what had been held below, and that's what the Court of Appeal was trying to say was wrong. The lockbox example is simply that the misrepresentation practiced on the claimant gave no cause of action because the claimant didn't do anything, didn't suffer anything. The key in itself had no value. All that had happened on the facts of the case was a resolution had been passed, and the resolution was the key. The resolution was a company resolution, but actually, in itself, it did no damage to the claimant, other than diminution in share value potentially. And that's what the Court of Appeal was saying wasn't properly recoverable as damages. The other point on this case yes, there is the point at paragraph 898, which is again a crucial passage, where at the very top of the page, actually just from the end of the previous page, Lord Justice Templeman, no, that's the Court of Appeal, it's their judgment, was talking about diminution in dividend. And diminution in dividend, likely diminution in dividend, has been fastened upon in subsequent cases as indicating that transactions between the company and the shareholder have to fall out of account when quantifying loss. That was not the point of the diminution in dividend. The diminution in dividend is a proxy for value. If my company is harmed so that the prospect of dividend is diminished, I have lost share value. That's all the Lord Justice Templeman, or the Court of Appeal was saying about diminution in dividend.
Sorry, where did they do
I should really read it. 897, the last sentence, below letter H. He, that's the claimant shareholder, cannot recover a sum equal to diminution in market value of his share or equal to the likely diminution in dividend. And that's been picked up and was picked up in Johnson & Gallwood as indicating that future lost income from a company could not be regarded as loss. But in fact, two things about that. One, in Johnson & Gallwood number 2 and in Gardner and Parker and later cases, future lost income actually has been regarded as being recoverable. And second, what is being spoken about here is just share value, it's pure share value, it's the loss of the interest in the company.
I mean, the central passage is perhaps a sentence just below H, but what he cannot do. This looks like a substantive proposition about the law of damages, that a shareholder cannot recover damages merely because the company in which he's interested has itself suffered damage.
Yes, my lord. And what actually the court is trying to explain, I would suggest, coming back to the previous between F and G, is explain why you can't recover damages because you had no loss. Later, in Stein and Blake...
Well, I mean, it's slightly tendentious to say that he hasn't suffered any loss, but you can say the only loss that he's suffered is consequential on the loss suffered by the company itself.
It's the idea of the pure diminution in share value as not being a loss.
If you were a widow dependent on your dividend income, then it'd be rather harsh to say that the lady had suffered no loss if the dividend income dried up. But what you could say is that her loss is simply a consequence of a direct loss, is an indirect consequence of a loss suffered directly by the company.
My lord is absolutely right.
That
And
in a
what-
sense is what the judge says at 898D. The deceit on the plaintiff causes the plaintiff no loss, which is separate and distinct from the loss to the company.
But what I was going to add to this was this just part of the discussion is that in Stein and Blake and in Heron and Lord Grade, Heron and Lord Grade had two members, the Court of Appeal who do in Prudential and Newman. It was accepted that where, as a consequence of an injury to the company, shares are devalued and the shareholder disposes of the shares as devalued, that loss is recoverable. So the proposition that we're concerned with here is I have my shares. Today they're not worth so much because of the injury to the company. Tomorrow they may be worth more, but they're the same thing. I still have my shares. Where I've disposed of the shares, that gives rise to a realised loss. The realised loss is actionable, recoverable as damage.
I suppose dividend, there's some rather simplistic analysis of how shares are valued in some of these authorities, and equally with dividends. But in principle, dividends are paid out of distributable profits.
Yes.
And so if a loss to the company results in a diminution in its distributable profit, then it may be felt by the shareholder in a form of a loss of dividend.
Yeah, and that takes you back to my submission that actually what the Court of Appeal were concerned with was dividend yield as a function of value. Just can I deal with Section 423 of the Insolvency Act? It's a slight red herring, but I've got to deal with this. It's relevant here when one's considering alternative causes of action. My learned friend relies upon Section 423, absolutely front and central. There is an answer to the creditor position, he says, the victim, shareholder perhaps. Go under Section 423 of the Insolvency Act. You don't need to worry about the direct cause of action, and the court can sort out any issues of double liability and make other adjustments. To which there is an answer. It's a very simple one. My learned friend accepts that my illustration of the problem from Tarleton and Macaulay, that's the old case of the traders coming off the shore with their canoe, which I referred to at paragraph 63 and 64 of our case. He accepts that is an example of a case where the reflective loss rule would bar the disappointed trader because the canoeists coming offshore would have their own cause of action for the injury that's been inflicted on them, and then has fed through to me, the claimant, in the loss of payment of my debt. My learned friend doesn't shrink from that, and that's one sees it at his skeleton argument at paragraph 23, I think it is. Paragraph 23, page 2732. The problem that case illustrates is that 423 has no application to it. 423 is concerned with remedying transactions between a company and somebody else where the transaction has an intention that the company has to cause the victim harm. So where a company is simply robbed, the company has no intention, the company doesn't enter into a transaction, there's no scope for Section 423 at all. It's just simply not available. And so far as authority is relevant on that point, it's in Principal Authorities Bundle 1, tab 2, page 507, at page 520. That's a case of, it's sometimes known as BAT against Sequana.
BTI.
It's also BTI 2014 LLC against Sequana. Depends. But at page, the question in the case was whether a dividend paid by a company could actually be the subject of a Section 423 case. And the Court of Appeal in a judgment given by Lord Justice Richards, held that it could. But at page 520, one sees at paragraph 53, there's a discussion about a requirement for section 423 to have a bilateral transaction. And their earlier first instance cases referred to that passage. Then at paragraphs 58, where the dividend case is dealt with, and 61, looking at, again, the dividend and transactions. The simple proposition is that Section 423 requires that a company has entered into a transaction for the purpose of harming a victim. And if the company hasn't entered into a transaction, its money is simply nicked. Section 423 doesn't engage. Again, touching on my learned friend's rejection or acceptance of the Tarleton and McGee example in my case, he said that the other example I gave of the creditor who's taken a guarantee from a defendant wrongdoer against a company, guaranteeing the creditor's debt to the company, with a covenant by the defendant that the defendant will not misbehave or the assets of the company will be properly applied. He says that that example is unreal and the court shouldn't worry about it. In fact, that's not right. The example is pretty much the facts of Giles and Rind. It's commonplace in shareholder agreements for joint venture companies for the shareholders to give covenants amongst themselves as to how they will behave. And the difficulty that the strict application of Johnson and Gore Wood principles entails is that those covenants really cease to carry weight. The damages that can be recoverable from them can only be the consequential damages and not the actual injury to the investment itself. So, for example, in our case, the consequential damage of the cost of trying to recover on our loans, on our debts. Johnson and Gore Wood itself, is dealt with at paragraph 44 of our case, page 2584, as to what it actually decided. I should, I think, show you the case so one can see how narrow it is. It's in Supplemental Authorities 1. Tab 18. The whole case begins at page 1555 of the electronic bundle. The order made on the case is at page 1622. And one can see between letters D and E the actual order made. Of these heads of loss, item 13 was anxiety and suffering, and 24 was a claim for aggregated damages. The anxiety and suffering pleading can be found at page 1667, where we've extracted the actual pleading into the authorities bundle. And the aggravated damages pleading can be found at page 1653. So those are nothing to the point for present purposes. All that's left is the order made as regards paragraphs 8 and 10, and those can be found at pages 1665 and 1666. The passage that seems to have been struck out of paragraph 8 is the last sentence at the top of page 1666. The plaintiff's claim in respect the present day difference in value between the pension rights to which he will be entitled in the events which have happened and the value which these rights would have had if payment had been made into the fund as aforesaid. That went, but the rest of the paragraph stood. And that caused quite a lot of problems when the matter came back to Mr. Justice Hart and then later to the Court of Appeal. And paragraph 10 went, which is an alternative case, which is diminution in value. For the avoidance of doubt, the plaintiff's primary case is that such payments would have been made. The effect of making such payments would have been to reduce pro tanto the assets of the company and the value of the shares therein. Upon this basis, such payments would have been made, and then there's an alternative claim put forward, and that was struck out. Now, we say that paragraph 10 makes it crystal clear that there was no contract between the plaintiff in the case and the company or the insurance or the provider of the pension, that any money in particular will be applied to the pension fund, the pension contribution. The pension contribution was a pure distribution if it came to be made. One can also see the point appearing in the judgment of Mr. Justice Hart, paragraph 194, electronic page 782, and then paragraph 237, electronic page 798. We've tried to engage with what actually was decided, what was by the House of Lords on the pension liability or pension claim, and how it was later dealt with in the Court of Appeal. Suffice it to say that ultimately, on the facts, it was shown that there had been no loss, because whether the money was in the company or in the pension fund would have made no difference. But it really, Mr. Justice Hart struggled with trying to work out what it was that had actually been decided on the pension case. So we have in Authorities Bundle, Principal Authorities Bundle 1, the two versions, Mr. Justice Hart, and then the Court of Appeal and Prudential against, Johnson Gorwood number 2. But we also say, when one's looking at Lord Justice Millett, a passage, now I should come back to in Johnson Gorwood, page 1620, he's grappling with what was decided in Prudential and Newman, and he goes further than I submit was actually decided in the case. But what he says is all transactions or putative transactions between the company and its shareholders must be disregarded. Payment to one diminishes the assets of the other. Now, pausing there, in a sense, if the company pays a debt to the shareholder, its gross assets are diminished, but its net assets remain unchanged. It substitutes. It loses the debt as it loses the money. And he goes on, in economic terms, the shareholder has two pockets and cannot hold the defendant liable for his inability to transfer money from one pocket to another. In principle, the company and the shareholder cannot together recover more than the shareholder would have recovered if he'd carried on business on his own, in his own name. So
I'm very sorry. I know I've read this in the past, but I can't find the passage at the moment. What
sorry,
page are you
it's
on?
letter H at the bottom of page 1620.
Thank you.
And the important point at this stage in Lord Millett's speech is that he's concerned only with shareholders. It's not creditors as such, and we say not creditors at all. His two pockets example is the shareholder, and he's really thinking of the sole trader shareholder, who can be said on the company, it's an alter ego for me, myself. That's what the two pockets is about. It's later at B to C that he made his remarks about debts. And that, on that point, he was the only member of the court who said anything about debts. And we say that was out of line with anything in Prudential and Newman, and indeed without the other members of the court in the particular case.
Could you help me by just giving me a few signposts, please, with regard to the overall shape of your case, so that I can approach what you're saying about Johnson and Gorwood in that context? But can I just put it to you in a series of propositions? Because it seems to me that one way that you have been putting it is the rule has got out of hand and been misconstrued. It is, in fact, a procedural rule that manages a potential multiplicity of plaintiffs, of claimants. That's one way you've been putting it, I think. Correct me if I'm wrong in a moment. Or alternatively, you could put your case by saying it should be confined to other classes of those involved with companies or in companies, not creditors such as ourselves, either because Johnson & Gore never decided that it did cover that, or because if it did, it should be pulled back from that position. So I'm just trying to find out where on that spectrum you are.
Perhaps I'm going to be Chinese in the proverb about riding two horses,
Right.
but actually I'm on both of those.
Okay.
What we say is that in its proper ambit, the rule has no application to non-shareholders, and indeed it certainly doesn't have application, if you regard it as having application to shareholders, it doesn't have application as regards debts. On that point, Johnson & Gore Wood went too far. Sorry, didn't decide debts. It's only Lord Millett who referred to debts. So Johnson & Gore Wood itself is narrower. And as to the procedural point, my proposition here is quite a limited one, really. It is that it is open to this court to decide that essentially where the court finds that there are the policy reasons driving the rule, then it would be open to a court to exclude a plaintiff. But that it's absent the policy reasons applying, one doesn't have to say, as Lord Millett did, there's no discretion, the rule must apply.
Formal argument, the latter argument is that there is a room for discretion, there's a room for judgment in the application of the rule. The former argument is more stark. This is a shareholder, a quasi-shareholder rule alone. It
Yes.
comes out of Foss and Harbottle. If it's wider than that, it applies not only to companies but to individuals and trusts, and it's getting out of control.
Yes, exactly, my Lord.
Is that the essence of what you're...
That's absolutely right. But I just there's a third strand at the bottom of all that lot, which is that in any event, it doesn't apply to pure creditors. There's a distinction between the creditor shareholder and the pure creditor, which is us.
Primary submission is creditor, even if he's a shareholder, is acting qua creditor, and therefore...
Well, I'm putting it slightly the other way around, that supposing you have a creditor who's also a shareholder, then one might argue that he is in a different, or she's in a different place from the pure creditor, simply because of the rules relating to company membership. Section 994 is available to a shareholder, not to a creditor, unfair prejudice petitions. Derivative proceedings are available to a shareholder, not to a creditor. Pure creditor can't bring derivative proceedings. So there is that distinction. There's the contract of membership is a feature, we say, of the origin of the rule. That's why when it comes back to Foss and Harbottle, that's a shareholder matter, not a pure creditor matter.
That is procedural. We were discussing this earlier in relation to prudential. We saw that the Lord Justice Templeman's reasoning was essentially based on the avoidance of double recovery of damages, and Lord Hodge took us to the passage where he pointed out that the shareholder's loss was not distinct from the company's loss. And so,
yes, I would slightly cavil at the proposition that in the Prudential and Newman, they were really concerned with the question about double recovery of the same damage. What they were primarily aiming to do was to show that, in fact, the claimant, the plaintiffs in that case, had no standing to bring a personal action because the personal action depended, it was a tort action where damages are the gist of the action. They had suffered no damage, and hence they had no standing. That's what the case was about. That
Well, it suffered no damage distinct. We went over this before.
Sorry, I understand.
No damage distinct from the company.
other than the diminution in value, the pure diminution in value. But as Lord Templeman said, or the court said, they still had their shares, and a function of being a shareholder in a company is that the value of your shares can go up and down as the fortunes of the company go up
Yeah.
and down.
Now, that's a very different approach from saying that because you happen to have a share in a company, and therefore you have available to you the remedies available to shareholders under the Companies Acts and under common law. Therefore, you are barred from pursuing your cause of action as creditor.
Well, my Lord, I absolutely see the point. My learned friend makes it forcefully, and it's a point that troubles Lady Justice Arden in Johnson and Gorwood number 2.
Well, I was picking you up on it because I thought you were telling Lady Black that was, at any rate, one of the horses that you were riding.
I'm riding that horse. Sorry, I am riding the horse. I'm submitting that given the genesis of the rule as being coming out of Foss and Harbottle, which is a rule concerned with shareholders and only shareholders, because Foss and Harbottle is essentially, with its exception, is the case when shareholders can and can't bring proceedings. That the position of being a shareholder matters when one's asking whether or not your claim can be trumped or you can be precluded. So I am saying
Foss and Harbottle strikes me as a red herring in all this. Foss and Harbottle is to do with the fact that a company has a separate personality, and therefore obligations owed to the company are enforceable by the company and not by its shareholders, who are separate legal persons from the company. And even a derivative claim is not brought by a shareholder as an individual. He's bringing it on behalf of, for the benefit of the company.
yes, but sorry, it's not a profound point I'm making, and my Lord may not care for it. But a creditor cannot bring a derivative action. That's all I'm saying. That there is actually a point. Does the rule engage with a creditor shareholder? Is there a distinction between a creditor shareholder and a pure shareholder? I'm submitting that actually a creditor shareholder is in a different place from a pure creditor. But I also submit that whether or not it's a creditor or a creditor shareholder, the debt claim is not one which is susceptible of the rule in Johnson and Gore Wood. So it's another strand to my bow.
Just so I can get it clear in my mind. So it seems to me, from what you've just said, that your primary case is, even if you have someone who happens to be a member, but they've got a debt, they can sue, and they're not affected by the reflective loss rule. But in the alternative, if you don't win on that, you say, well, there's a substantive difference between someone who is a member and a creditor and someone who's a pure creditor.
Exactly.
So are those the two horses that you're
Those are the two horses. And I'm sorry, I wasn't being articulating the point clearly enough.
But what you'd be saying is that the reason behind the rule is that the shareholders' diminution in the value of the shareholding or the future loss of dividends is in fact directly reflecting the loss that the company has suffered as a result of what's gone wrong for the company. And that's the rationale for the rule, and it doesn't go any further than that.
That's the beginning of the whole point. Yes.
That's the beginning and end of the whole point.
So there are various stage gradations where you're looking at the creditor position. At that point, the creditors don't even come into it.
No, I'm looking at it more from the basis of the rationale for the rule.
Exactly.
The principle underlying the rule, as opposed to the practicalities.
Milady, I respectfully agree. But I have already touched on the question, and I probably should get there now, of the pure creditor, the creditor position and double recovery, double liability. These are features, these are dealt with in my skeleton at 2589, 2599, paragraphs 50.2 and 76.1 in particular.
50.2 and?
2599.
Yes.
And taken on...
Sorry,
Paragraphs 50.2.
Paragraphs 50.2 and 76.1
Thank you.
of my skeleton. My learned friend addresses the point at his skeleton, paragraphs 14 onwards, which begin at page 2725. Now, the proposition at paragraph 14.2, we say is not actually made good. Gray and Lewis I've already dealt with. It's a straight, old-fashioned, proper plaintiff rule in a direct, simple cause of action. The other proposition is, that's referred to in paragraph 14.2, is Lord Millett, with his attractive direct language, putting a proposition which is not immediately obvious, if I may say it. The actual question in the present case is whether there's going to be double recovery. And double recovery doesn't follow simply because one has a company and an individual, both of who have a cause of action. In the present case, and the reason why it's so hard fought by the defendant is precisely because there will not be double recovery. The company's never going to do anything. It's only going to be recovery, if at all, on the action brought by my clients in this country. Then one sees paragraph 14.3 with the important policy rules, where one notices that 3 of the examples are statutes. In the last one, the penultimate one, the Law Reform Miscellaneous Provisions Act, Parliament had to legislated to avoid loss of future earnings in the case of a deceased person being recoverable both by the estate of the deceased and by dependents who had a claim for loss of dependency. Until Parliament stepped in, there was permitted from the defendant what could be to double recovery. The double liability mini liquidation point, paragraph 15, I've already addressed the court on the Kaupthing case, and what we also say, there's another proposition here which I need to deal with, which is paragraph 15.1. We don't accept at the moment that there are any valid claims against the defendant companies other than our claim. And we take the position that we would have been paid once but for the actions of the defendant. So we don't see that there's going to be any question of damages being reduced. That statement goes nowhere.
It's quite an important point in principle because it demonstrates that the debt you're owed by the company is not necessarily the same as the damages which you're owed by the defendant.
Well, my Lord, yes, but what I would submit about that is that where the damages is the whole of the debt, it's one and the same.
Well, yes, but as the example indicates, it wouldn't be the case if a company was, for example, in such dire straits that you would never have recovered the debt in full as an unsecured creditor.
Well, sorry, my Lord, I on the facts, I have to make, I dispute the proposition because the law has never objected to the first past the post principle. That's why if we had been able to and diligent in getting our third-party debt order in this country, we would have been paid in full. The law doesn't, whenever a creditor comes along and says, I want to be paid, require the defendant company before execution is entered into to have a mini liquidation.
No, I wasn't suggesting that, but it just indicates that the two claims are not necessarily for the same amount.
I would accept that, but I'd also suggest that if it came to it, in the argument where you could imagine that somehow or other we had tortious damages which didn't cover the whole of our debt. What would happen, I would submit, is that our debt would be diminished pro tanto, and pro tanto the defendant, would step into our shoes.
How do
But
you
even
work that
then,
out if there are consequential loss? I mean, as you've got to claim for consequential
We do.
losses as well as the debt.
we do.
Let's say, well, I'm just not quite sure how that would work out. Let's say the company was only ever going to be good for half the debt, so the assets are taken away. The loss in terms of non-payment of the debt is just half the debt. So let's say if the debt's at 100, you only were ever going to get 50, so that's damages of 50, but you then have the consequential losses of going around the world and so on, trying to do things. That's 20. How would it work in practice? Would the court that awards you damages then say, well, you get 50 for half the debt, which would have been recoverable, and 20 for the other consequential losses, so you can still work out the subrogation element?
But Lord, I would submit that's right, and probably, but probably the way it would work is that the consequential loss would be regarded as the first recovered. That would be a matter, if we go to trial and we get judgment for the consequential amount, we would also get, in our case, judgment for the full amount of the principal. But supposing the court said, well, actually, no, the companies can pay you half the debt, we would then get damages for half the debt, and the defendant would step into our shoes for the half the debt. But it's a hypothetical for the purposes of the present appeal. The Swinson, my learned friend relies on Swinson at paragraph 15.2 of his skeleton. That case, he'll no doubt take you to it, that case is only a case on mitigation collateral benefit. It's not actually a case on the point we're concerned with at the moment, which is Moule and Garrett, not even mentioned in that authority. It's simply the question, how far payment by a third party voluntarily to discharge a debt meant that the measure of damages suffered by the plaintiff was diminished when the plaintiff had been responsible for an improvident loan. We rely on, for the Moule and Garrett proposition, the simple statement, Chitty, 33rd edition, chapter 29, 105, and the page references 2793 in the electronic bundle, supplemental bundle 4, tab 10. The double jeopardy is disclaimed by the defendant as being actually a policy reason, and one finds out at paragraph 17 of the defendant's case, page 2728. Causation, paragraph 18 of his skeleton, his case rather, that's not the point we submit. In the real world, our loss was caused by the theft. It's not caused by the failure of the liquidator to sue, although that was part of what they intended. And one can see Lord Hutton, indeed, in Prudential and Newman, recognised that causation wasn't actually the problem in the Johnson in the reflected loss cases, and that's in the electronic version 1608 at letter D.
Also, the proposition as stated begs the question.
I beg your
If a company chooses not to exercise its remedy if a loss to a creditor is caused by the company's decision, well, that's only true if the appropriate person to exercise a remedy is the company.
Yes, but it's also that slightly begs the question: who's the appropriate person to pursue a loss in a case such as ours? The liquidator actually could not, on the facts, return the money that had been taken to England, there to await our execution.
Yes. The main point I'm making is that the way it's put in paragraph 18 presumes that only one person can bring the claim and that it ought to be the company.
But, my lord, yes, it slightly begs the question. But how far causation is the problem with determining quantum of loss and a foundation for the rule against reflective loss is one of those matters which is exercised academics. But one can see, as I submit, in Lord Hutton, in his speech in Johnson Gore Wood, one looks actually at the facts of the particular case and sees where's the reality, what caused the loss. As to settlements in the present case, supposing the liquidator had gone to Mr. Sevilleja and said, oh, by the way, we'll take £10 or $10 and give you a release, that couldn't possibly be regarded as precluding us from actually making good our claim for the damage which has been brought about by putting in place this particular liquidator. What essentially is being said is that we could and should have gone off to the BVI to fight expensive proceedings in a liquidation in the BVI with doubtful outcome, rather than doing what's the obvious thing to do in a case like this, which is to sue the defendant for having taken the money from the companies and left us unpaid. It's as simple as that, actually. Giles and Rind, coming back to the proposition, which I'm probably now repeating myself on, so it's my last proposition, is Giles and Rind, we say, is actually absolutely right. The Court of Appeal in that case saw a situation in which a strict application of the rule without regard to the realities was going to work in justice. And it wasn't necessary to see that there was legal impossibility in bringing a case, as decided in the Court of Appeal here in the present one, nor is it necessary to see that there was practical impossibility when one could see that the reality is that actually there's no claim that's going to be made against the defendant by the company in question. There's no double.
Sorry, isn't that practical impossibility?
It's equating practical impossibility with reality. What I'm saying is that
I thought that the exception in Giles and Rind was predicated on practical impossibility brought about by the defendant.
It was, but it was a situation, as I'm putting it now, in which the defendant has in fact engineered a case where there will not be litigation. It's not because he's made a settlement with the liquidator. It's simply because he's actually...
He has sufficient control over the company,
he's achieved, yeah,
either
exactly.
himself or through his confederates, to stop it taking action that it might otherwise take.
Exactly.
Right. You keep referring to the Court of Appeal in our case talking about legal impossibility. I thought that they only did that because on the facts of this case, they weren't persuaded that this was a practical impossibility case.
My lord may be right. I had read it as being a greater threshold, a legal impossibility requiring greater inability, if you will, because of the that there was no legal way in which the claim could be run. But maybe I've misunderstood their rejection of Giles and Rind. But whatever one can say is that, other than I think one case a long time ago, the exception hasn't been applied, and it's now the generally accepted view, I think, is that now, as a result of the Court of Appeal's decision in the present case, the exception has no real function. But
Mr. Bompas, I hate to mention it, but you've actually run out of time.
I'm sitting down right now. At 20
Well,
past.
do finish your sentence.
Well, I had intended to conclude, at 20 past.
You have completed your submissions.
I've completed my submissions.
So, thank you very much indeed. Ms. Faber?
I have no further submissions.
Mr. Knox?
My name is Lords. We are very grateful indeed to allow such short notice and convening this matter. We apologise for that. So if you've seen the reasons, I don't propose that. And I apologise in particular, obviously, to Mr. Lewis and his team, because we realised we more work on him rather than last week. My lords, my lady, my lords, you'll see there are two basic points we make. Criticisms of the wide, as we say, exclusionary rule upheld by the Court of Appeal. First, we say it is founded on an artificial and absolute rule of causation. No doubt, a decision by an insolvency practitioner to settle a company's claim in an insolvency for common loss will, in accordance with usual common law principles, often break the chain of causation between the common wrongdoer's alleged wrong and the individual's resulting loss, resulting, that is, from the company's wrong. But we say that's not necessarily and always the case. It's always a matter of fact. And it's wrong to elevate something, causation questions, into principles of law rather than usual factual questions to be decided in accordance with the usual principles of remoteness. Secondly, we say the absolute rule is based on only one of many potential policy considerations, which are very different, really, for this court, for any court, to weigh up without empirical evidence. My lady, just by way of preliminary point, we do rely, particularly on Steinfeld, QC's article, not only because we say it shows an entirely timely recantation of his former submissions, but also because it's quite an amusing article.
You have to do it all the time. We understand that.
I'm not even sure you need to recant submissions.
Well, I agree,
But
he compares the rule, the no reflective loss rule, to Marmite. You either love it, and obviously Lord Millet is one of those, or you hate it. And Lord Cook was one of those. And Lord Hutton didn't seem to like it very much, but he thought it was good for you. And so he went along with it. That's what it more or less comes down to. And our position is that no matter whether one likes it or not, we submit it's quite unnecessary and quite unjust, and it's not good for you. It may not be bad for you, but it's not good for you. And we adopt in particular Mr. Steinfeld's thesis and conclusions in a summary. First of all, before Prudential and Newman, no problem was perceived by Chancery judges, and he gives examples of Mr. Justice Cross and Mr. Justice Brighton, I think, in dealing with breach of trust claims by beneficiaries, which would now be regarded as ousted or barred by the reflective loss rule. And indeed, I would add to that, no one seems to have thought that this was a problem at all. Secondly, he says it can't be right as a matter of policy, if one is looking at policies, to allow defaulting trustees to rely on the rule. How come that they can rely on that? And I say, obviously, by extension, well, if that's right, where does it stop? How can it be right for the fraudster to rely on the rule? And so on. One can go all the way down the line. Thirdly, he says, and I respectfully submit there can't be much answer to this, problems of double jeopardy and double recovery can be dealt with by case management. And his conclusion at page 285 is quite an amusing conclusion. If I can just go to that, because it's the title of the article is In the Looking Glass, Holding Companies in Reflective Loss, and it's at tab 2 of our authorities bundle, which was served yesterday, or supplemental bundle. And at the end, he concludes at page 284 with his two main legal conclusions. Basically, surely this doesn't apply to breach of trust claims. And secondly, the rule really is just based on the need to prevent double jeopardy and double recovery, but that can be case managed. And then he concludes with all the zeal of a convert at page 285, the law took a seriously wrong turn when in Prudential the court elevated what was a relatively simple everyday problem concerned with assessment of damages into a principle of causation, and that's exactly what we say. The reasoning of the Court of Appeal seemed convincing at the time, but the application of the principle has been controversial and has caused and is liable to cause serious injustice. As was said appropriately enough in Alice Through the Looking Glass, when she thought it over afterwards, it occurred to her that she ought to have wondered at this. At the time, it all seemed quite natural. I think it's about time our highest judges should also now think it over and wonder why it was ever thought necessary or just to have this rule at all. And we do entirely adopt that, if I may say.
So that seems to be an attack on Newman itself.
Yes, yes. I accept.
And I'm not sure
quite
Mr. Bompas was going that far.
No, my lords, he's not going that far, but he certainly is saying the rule should not be extended so far as it has been. I'm not inviting you to, as well, overturn Prudential and Newman, but I am saying, in any event, that the question of the...
forgive me, why aren't you inviting us to do that?
Well, my lords, one can imagine situations in which a claim by... one can imagine a situation in which one says about a claim by the shareholder in relation to his claim for diminution in value, one can say, well, you signed up to the company. It's implicit in that you leave it to the board of directors while the company is solvent. I emphasize that. You leave it to the board of directors to decide what to do with the company's assets. The company's assets include the claims which both it and you, the individual, have reflectively. And it follows from that you are bound that you cannot claim if the company doesn't want to claim. If the company if the board of directors settles, then you're bound by that decision. Now, one can say that as a general principle. One could imagine, of course, this is part of the problem, one could imagine a case where the individual shareholder has a contract, common wrongdoer, where in terms it recovers the possibility that the common wrongdoer's negligence will result in a loss and diminution in shareholding. And what then? Now, it might well be said in that situation, surely he would be allowed to sue the common wrongdoer. But on the whole, that's a rather extreme example, but on the whole, that won't be the case. So, my lords, I don't press, and I've got limited time, I don't press, as it were, for an argument that the prudential rule is necessarily wrong. My real concern in this case is what happens when a company goes into insolvency. That's the thrust of it. It may have consequences on what the position is if the company is solvent. But, my lords, I don't propose to get into that. Except one can see the logic of where I'm going could lead you right back to saying Prudential and Newman's wrong. But I don't press for that. My lady, can I deal first with causation? Our concern, in broad terms, is with this type of situation. There's wrongdoing by the common wrongdoer, and breach of duty both to the individual and to the company. And that wrongdoing results in the company going into insolvency. Now, the consequence of the insolvency is, A, the owner loses control of the company to the liquidator. He may or may not be a director, but my lord, there are all sorts of variations. But that's one consequence. He loses control of company's affairs. Secondly, the company has limited funds. Thirdly, the liquidator, in that situation, not unreasonably settles a claim against the common wrongdoer, let us say for £300,000, rather than, for the sake of example, at £1 million, which it could reasonably be held to have, but 300,000 is not an unreasonable deal. The consequence of that is that the owner loses out in the insolvency, A, on the payout, on the extra payout he would have got, A, in relation to any guarantees which he's got for the company's rights, he's given for the company. Second, in relation to loans, which he has outstanding from the company. And thirdly, and residually maybe, in relation to his shareholding. But that's a perfectly possible scenario. Now, what we say is the proper analysis is this. First, we say in that situation, the owner has, properly speaking, suffered a loss of his own. First, he is liable on guarantees to an extent which he would not have been liable had, let us say, the full amount of £1 million been covered, and had he been in control of it. Secondly, he will lose out on his loan accounts. He will get, let's say, a smaller dividend than he would otherwise have got had the settlement been £1 million, therefore £300,000. And thirdly, he will lose out by virtue, he won't get anything, which he might have got otherwise, for the value of his shareholding or for his shares. We say that is a loss, that loss could easily be referable to the part of the claim that the liquidator does not pursue and is settled. We say that is a loss as a matter of law, and what I might call that is clearly shown by Lord Bingham's second proposition, where it is accepted that where a company doesn't have a cause of action for loss, but the individual does, then he can sue for diminution in the value of his shareholding. So on the face of it, we say, well, that is obviously, diminution in value of shareholding is a recognised loss. Secondly, we say in the example I've given, the losses are indeed the result, and could properly be said to be the result, of the common wrongdoing, that is to say, within the scope of the duty of the common wrongdoer, to save the innocent person harmless against. Thirdly, and this is really the crux of it, we say the liquidator's decision not to pursue the claim beyond £300,000 does not necessarily break the chain of causation, nor should the owner necessarily be regarded as bound by it. And we say this is for the following reasons. The insolvency itself was the foreseeable consequence of the common wrongdoer's wrong, and therefore all the consequences, including the loss of control to the liquidator and all the financial constraints imposed on the liquidator, likewise, can properly be regarded as the consequence of the wrongdoing. And therefore, to allow the common wrongdoer to set up the liquidator's settlement of, let's say, £300,000 in answer to the victim's claim for the balance of whatever it is he'd have got in the insolvency, would be to allow the common wrongdoer to take advantage of his own wrong. We say that cannot be the law. There's no reason why the law should be like that. And our position is that subject, of course, to the usual rules of remoteness and causation, the victim in that, I call him the victim, in that situation should be allowed to pursue such part of the claim as has not been pursued against the common wrongdoer to recover that, whatever sum he would have recovered in the insolvency, had the full £1 million claim been pursued. It won't necessarily, of course, be £700,000. It might be considerably less. It all depends what the nature of the insolvency was. But certainly in relation to claims made against him under a guarantee, it could be a pound for a pound, because he'd be entitled on the face of it, if this were the situation, to say to the creditor, well, look, I'm entitled to set off the entirety of the company's claim, which had accrued before the liquidation, as by way of set-off, as a defence under the guarantee. So it could have very serious implications in relation to guarantees given by the owner. Now, my lords, you might say, well, you're really saying, Mr. Knox, that Christensen was right and Gorwood was wrong. It comes close to that, but it's not quite that. Because I do say Christensen was rightly decided, but for slightly different reasons than appear to be advanced by the owners in that case, or indeed decided by the Court of Appeal. The Court of Appeal's judgment is, I can deal with this, I hope, briefly, I'm conscious of the time. If one goes to Primary Authorities, Bundle 2, tab 16, at 10.9, is where the case begins. Now, the relevant passage is at 10.14. Sorry, I said 10.16. Now, this was part of the ratio in Christensen, which was disapproved by Lord Bingham. It's the only bit of Christensen disapproved of. And Lord Bingham disapproved of this in Gorwood at Supplemental Bundle 18, page 1590A. Just this passage. And it's the passage you see beginning, we consider, therefore. That's the passage disapproved. You'll note other claims which the Christensens pursued for losses under the guarantee. You'll see them over the page, 281. Lord Bingham said nothing about that. Now, what we say in summary about this case is this was a case where the decision, where the wrongdoing had obviously resulted in financial catastrophe. And it was the liquidator of the company which settled the claim. But what was not argued was that the usual, what you might call prudential rules, should be disapplied because it was the wrongdoing of the common wrongdoer which caused the company to go into insolvency in the first place. That doesn't appear to have been argued. It may have been an argument that was available on the facts, but it doesn't appear from the case. So we say, had the point been put in Christensen along the lines we put it, there's no reason to suppose that we don't know what the House of Lords would have said, but we say Christensen, if that was a proper view of the facts, would have been correctly decided. So that's what we say on causation. Christensen, understandable that it's disapproved of, bearing in mind the way it's actually drafted, the judgment, but if one had rewritten, so to speak, the arguments, and the Court of Appeal had looked at different arguments, it could have quite correctly come to the very same conclusion. Lady, as far as policy considerations are concerned, really, I just make 2 points. This is very dangerous territory. Of course, we accept that the need to protect creditors of insolvent companies is one policy consideration, and that's the one that Lord Millett focused on. But there are others, 2 other obvious ones. First, a common wrongdoer cannot take advantage, or should not be allowed to take advantage, of the consequences of his own wrong. And the second is that people who have been victims of a wrong, who could be a very serious fraud, should not be put in a position where they will find it harder than they would otherwise have found it to exercise their normal rights. Now, the answer my learned friend gives, essentially Lord Millett's answer, is, well, it's not that difficult to intervene in an insolvency. The difficulty your lordships are placed in is how on earth to assess that in real life. We've set out the arguments in our case intervention. I don't propose to repeat them. But we say it's very difficult for the court to weigh up one type of policy consideration against another. And what is wrong with the reflective loss rule is it gives primacy to one policy consideration without even considering the others. And that's why we say, at the very least, one other policy consideration that must be taken into account is the question of not allowing a wrongdoer to take advantage of his own wrong.
Well, thank you very much indeed, Mr. Knox. Yes.
Good afternoon. What does it mean to say loss is reflective? To paraphrase, it means it is secondary or indirect. It is parasitic. It is consequential, to adopt another term used this morning. The positive proposition is that reflective loss would be made good if the company was replenished. The negative corollary is that if the company had not suffered the underlying primary direct loss, then there would not have followed the consequential, secondary, indirect loss to the claimant seeking to recover reflective loss. There is a direct reflection as between the loss of the company and the loss of the shareholder or creditor. But vis-à-vis the third party, wrongdoer, negligent advisor, the loss of the shareholder or creditor is indirect. It is a function of the primary loss suffered by the company. So in the prudential cash box example, it is the company's money that is stolen. The loss to the shareholder or to the creditor, even the shareholder creditor if the investment was by way of loan capital, is secondary. That is the context in which the justifications for the reflective loss rule fall to be considered. It helps explain why the problems of overlap and prejudice arising from allowing concurrent or consecutive claims are met by exclusion of the claim for the secondary or indirect loss by the shareholder or creditor.
Can I just ask you about the cash box example? Suppose the cash in the cash box was the means for the company to discharge some particular debt which another person had guaranteed. Would the person who'd given the guarantee of the company's debt be able to sue the person who stole the cash from the cash box?
I'm going to come to guarantees later. As the law stands, no. That is the ratio of the Court of Appeal in Webster and Sanderson's, that the reflective loss rule applies to creditors, it applies to debts, and guarantors are a type of creditor. The other answer, to trailer it now, is that in the case of guarantors, who are a particular type of creditor, it may be that there is a separate and distinct loss, so that one is outside the reflective loss rule and within Lord Bingham's Proposition 3. So much of the case law is about claims for reflective loss, where there is for some reason no claim by the company, or where the company claim has already been disposed of. But as we analyse the principles, we must test them at each stage by reference to their impact on two other scenarios. First, where claims are being brought concurrently. That is what the appellants and the interveners wish to permit. By the first issue, they wish to permit concurrent claims by a creditor for reflective loss and by a company for the underlying primary loss. By the second issue, they wish to permit concurrent claims, even we say by shareholders, for reflective loss concurrent with the company claiming for the primary loss it has suffered. Secondly, we need to test the principles by reference to the scenario where the creditor or shareholder is claiming, the company is not yet claiming, but the company could still do so. Again, as exemplified by the first past the post reference, the appellants and interveners wish to permit the reflective loss claim to proceed first in time, with the company claim perhaps to follow later. In both scenarios and on both issues, we say they require the court to depart from Johnson and Gorwood under the 1966 practice statement. The relevant principles in relation to that statement and the case law thereon are set out in paragraphs 10 and 38 of our written case. We say there can be no suggestion there's been a relevant change of circumstances since 2002. And we also say it cannot be shown that Johnson has led to decisions that were unjust or contrary to public policy. The relatively few authorities we have before you, where there are expressions of judicial regret, can be answered by different solutions. There are also, we say, more appropriate, different solutions to the intervener's complaints. So with that introduction, I want to focus first upon issue 1, are creditors, and within that, the specific category of guarantors covered by the reflective loss rule. I'm going to follow the three main submissions in my written case. First, precedent. Secondly, the test and justifications. Thirdly, alternative remedies. Then I will deal with the APPG's intervention before addressing trustees, guarantors, and time permitting, some comparative law. First, as to precedent, we must test the ratio of Johnson by reference to the materials that were before the House of Lords, excluding reference to the evidence and facts that later emerged at the trial before Mr. Justice Hart. The hearing before the House of Lords arose on a strikeout application based on pleadings alone. The House of Lords unanimously struck out the pension contribution claim. There were only two relevant pleas it was looking at, as you were shown in part this morning. They're set out in our written case at paragraph 8. The first was that, and this is Supplementary Bundle 1, tab 18, page 1653 of the electronic bundle. Paragraph 23.1.09 of the re-amended statement of claim. The plaintiff claims the diminution in value of pension caused by the inability of Westway Homes to maintain payments due under the said policy. Secondly, on the pleadings, there was also paragraphs 8 to 10 of the Schedule of Loss, which referred to the pension as part of Mr. Johnson's remuneration in his capacity as director. That's electronic bundle 1665 to 1666. That schedule refers to an expert report but there's no suggestion that was before the House of Lords. On one view, we should test the ratio of Johnson even more narrowly, only by reference to the re-amended statement of claim. The second preliminary issue, set out by Lord Bingham at page 20E, focused upon paragraphs 23 and 24 of the re-amended statement of claim. So against the background of that simple plea, Lord Millet's speech plainly extended to creditors. See his reference to other payments for which there was a legal claim to be paid, page 67B to C. It is often said that Lord Millet stood alone. We say that overlooks the position of Lord Gough, who at pages 41F to D agreed with Lord Millet's analysis of the case law. In context, we say that was agreement with the propositions that flowed from the case law as set out by Lord Millet, including as to creditors. The reason Lord Gough specified Lord Millet's analysis of the case law was not to exclude his agreement with principles arising therefrom set out by Lord Millet, but instead to juxtapose that agreement with Lord Millet on the one hand, with his agreement on the other hand, with the analysis of the pleadings by Lord Bingham. Lord Bingham was the only judge who had undertaken that detailed analysis of the pleadings.
Give us the MS page reference for Lord Gough, please.
Lord Gough is at,
1595.
I'm grateful, page 41G to H.
I think that's right, isn't it? That's where he says, I agree with the analysis of that case, that's prudential, and of the other cases following upon it, set out in the opinion of my noble and learned friend, Lord Millet.
Exactly so, I'm grateful.
He then goes on to agree with the specific conclusions as to what is and is not recoverable reached by Lord Bingham.
Yes, and so the dilemma is either that he has said nothing about what he agrees with as to matters of principle going beyond the strict confines of case law analysis, or, as we say, he has agreed with Lord Millet's analysis of the case law and the relevant principles before turning to his agreement with Lord Bingham.
What about Lord Hutton? What about Lord Hutton?
Well, I don't put forward that Lord Hutton is in agreement with Lord Millet on the creditor point. But what I do put forward instead is a more general point about the unanimous position of the House. Lord Bingham, at page 36H, thought it plain that the pension contribution claim should be struck out. If, as the appellants have suggested, that turned on the pension contribution claim being a matter of expectation to which Mr. Johnson had no enforceable right, a distribution by WWH, one would have expected Lord Bingham to defer that claim, like others, to be tested at trial by the evidence. He was presented with only the pleaded case that there was the inability to maintain payments due under the policy, as well as the point on remuneration. But nonetheless, it was considered plain by Lord Bingham and all their lordships that the pension contribution claim should be struck out. So we say, therefore, that no distinction can be drawn between distributions as of expectation and distributions as of right. Therefore, the unanimous ratio of the House of Lords extends to debts. I accept it's in the context of a shareholder, but it extends to debts. To depart from Johnson on issue 1 and hold that the reflective loss rule does not extend to creditors, we say it would have to be shown that its extension to creditors has led to unjust results contrary to public policy. That is logically separate from the issue 2 question of whether there should be flexibility. The focus of the appellants and the interveners has been more, we say, on issue 2 in relation to injustice. If Giles and Ryan is upheld in this court and perhaps clarified in terms of practical impossibility, that necessarily undermines arguments that it is unjust for the rule to extend to creditors. If the rule is made more flexible still, then the position on creditors will be a fortiori. This correlation may be common ground between us and the appellant. It's in my learned friend's case, written case at paragraph 55. So we say injustice cannot be shown by reference to the case law as arising from extension of the rule to creditors. The leading case on creditors is Gardner and Parker. That is in primary 1, tab 4, at page 620. There is no suggestion in Gardner and Parker that Lord Justice Neuberger, perhaps he likes Marmite, thought the rule was operating in justice. The relevant company was Scout-Vale. Administrative receivers had already brought a Section 423 claim against Mr. Parker, which was in principle on behalf of all victims, including BDC as a shareholder and loan creditor of Scout-Vale. BDC's rights had then been assigned to Mr. Gardner. The facts of the company claim that had already been advanced are at paragraphs 15 to 16 on page 624. The Section 423 claim had settled for £350,000. Lord Justice Neuberger rejected the argument that the reflective loss rule should be disapplied because of that settlement. There was analysis of Giles and Wright. Lord Justice Neuberger held that there was no evidence of financial or other pressure to release Mr. Parker from his liability to the company, or that the settlement with the company was generous. That's paragraph 63 to 66 on pages 636 to 637. So we say that there is no case law before this court showing the extension of the rule to creditors to have operated in justice. We will come to deal with the case law in more detail and other authorities on issue 2 in relation to flexibility and Giles and Wright. My second topic on issue 1 is to focus upon the 4 policy justifications for the rule in the context of whether it should or should not apply to creditors. My learned friend has this morning revived the possible distinction between shareholder and non-shareholder to creditors. We do say that's unworkable as a distinction for the reasons given by Lord Justice Flo and Lord Justice Lewison. It has never appealed to any judge and should not appeal to this court. Many of the points we'll look at in relation to the 4 policy justifications resonate on issue 1 in relation to creditors and issue 2 in relation to flexibility. And we will see that many of the points apply equally or a fortiori to creditors than to shareholders. So the first policy justification is avoiding double recovery or double liability. Here I am at paragraphs 14 to 16 of our written case. This problem arises equally, irrespective of whether the reflective loss claim is being pursued by a creditor or a shareholder. We do say that the appellant's case has been inconsistent on the appropriate answer to this problem, sometimes within the same paragraph, which reflects the very real nature of the problem. At times, the appellant has said that the problem can be avoided by subrogation or in restitution. That's in their written case at paragraphs 50.2, 76.1 and 97.1.4 on our facts. It was this morning in relation to Moule and Garrett. At times, it is said double liability is unobjectionable. The wrongdoer has assumed parallel responsibilities, has assumed two duties of care, and therefore may just have to pay twice. That's paragraph 76.1 and 76.4, and perhaps also paragraph 97.5 of the appellant's written case. We say double liability is inappropriate, and the reflective loss rule rightly prevents it, both in shareholder and creditor situations. There is only a single primary loss caused to the company, of which the claimant's loss is reflective. So neither the asset stripper nor the negligent advisor or bank should have to pay twice. That begs the question of how double liability can be avoided if, as Maloney Friends suggest, the reflective loss rule is to be disapplied, especially where the creditor or shareholder claims first in time. Before we go on to consider the possibilities for discharge of the wrongdoer or a credit to the wrongdoer, we need to put them in the common context here so we see the implications of the problem. Reflective loss cases usually involve insolvency of the company. If it is solvent, it can pay its creditors, so no creditor problem will arise. Reflective loss claims are usually for damages or equitable compensation. The claimant will have to prove its loss. This entails determination of whether the company would or would not have been insolvent anyway, absent the wrong. If the company would have been insolvent anyway, then the reflective loss claim can only succeed to the extent of the dividend payable absent the wrongdoing. This was illustrated by my Lord Sale's example this morning. If the company would not have otherwise been insolvent, absent the wrongdoing, then the problem of double liability arises in an all or nothing sense. So if we take an example similar to that this morning, assume that absent the wrong, a company would still have been insolvent and would have paid creditors a 50p dividend. Because of the asset stripping, the company dividend will be only 10 pence. The creditor or the shareholder, if allowed to sue, notwithstanding the reflective loss rule, could only recover by way of damages 40p in the pound from the wrongdoer. The problem is, first, what's involved in the court arriving at those two figures. The inquiry necessarily mirrors a liquidation. See paragraph 15 of our written case. This is actually a bigger problem in the creditor claim scenario than the shareholder claim scenario. If a shareholder can prove any reflective loss claim, then the company would not have been insolvent absent wrongdoing. It would have been able to pay its debts and still have a dividend for the shareholder. But the inquiry will still be necessary as to whether the company would or would not have been insolvent, which entails considering fully the company's financial position. And all of this will have to happen at trial if the reflective loss rule is made flexible as suggested in relation to issue 2, or if it is disapplied to creditors as suggested in relation to issue 1.
In that context, would the burden of establishing the insolvency in any event lie on the wrongdoer? If there was abstracted from the company a sum greater than the creditor's claim against the company, could the claimant make that claim and leave it to the wrongdoer to establish that the company couldn't have paid it? Is that how it would work?
We say no. We say the burden would be on the reflective loss claimant. We have to put all of these points in the context both of the alleged asset stripper and the negligent bank, the two examples advanced against us today, so to speak. We say
the burden's on the claimant.
The burden would be on the reflective loss claimant to show that, but for the wrong, the company would still have had adequate funds to pay out on the shares in dividend or to reflect in a certain shareholding value, or would still have had adequate funds to pay out the debt in full.
My hypothesis was that there had been abstracted from the company more than the debt. So would that not be enough to create a prima facie case that adequate funds were with the company at the time?
It would all turn on the evidence. If it was a simple company, yes, but if there are many other debts, then it won't be immediately the result from that example that the extraction of that money is what tipped an otherwise solvent company into insolvency.
The mere existence of balance sheet insolvency wouldn't be conclusive, would it? Because companies can be balance sheet insolvent and still continue to trade and pay their debts on a first come, first past the post basis. There would have to be an intervention by another creditor to bring about a formal insolvency to prevent the claimant from being paid.
Well, in the creditor situation, there will be no reflective loss claim unless there is an insolvency, because in that case, the creditor can recover from the company. Yes, we accept that balance sheet insolvency is not going to be determinative, but we do say that there will have to be a mini liquidation inquiry to analyse, as per my Lord Sale's example, what the dividend would have been once one gets past the burden of proof question.
And it's not necessarily just going to be a mini liquidation inquiry. And really, going back to my Lord's point, I mean, companies, when they don't have their assets taken away from them, may go on trading. They may have expectations, not rights as yet, but expectations of very valuable contracts in the future. And that may have been the case with this company, because much more money was taken out than just the value of the debt. So why isn't it just an inquiry as to the loss that has been suffered by the claimant, rather than is the company purely balance sheet insolvent or not?
It is an inquiry into that loss, but it is an inquiry which will depend upon the counterfactual of what would have happened absent the wrongdoing. And therefore, when the company is insolvent, that will have to engage with whether the counterfactual would or would not still have been insolvency. Is that an appropriate time?
Oh, it's past an appropriate time. So it's always desirable to let exchanges between council and the court go on until they've reached whatever resolution they're going to reach. We'll be back at 2:05.